Welcome to Caracomp Insider, where high-tech facial recognition meets real-world intelligence. A European court just ruled that the agency which pseudonymizes a dataset, swaps names for codes, blurs identifiers, still bears full GDPR obligations for that data. Not reduced obligations. Full ones. The blur doesn't shrink your legal exposure. It shifts the entire burden onto you. If you work anywhere near facial images, case files, or biometric evidence, this matters right now. An EU court examined whether pseudonymized data where direct identifiers get replaced with codes, counts as personal data under GDPR. The answer depends on who's holding it. For the original controller, the organization that created the pseudonymized dataset, the answer is an unqualified yes. They can still re-identify the individual. So the question threading through this whole ruling is deceptively simple. Who has the key? The court introduced what's called the reasonably likely standard for re-identification. It doesn't ask whether someone could theoretically reverse the pseudonymization. It asks whether re-identification is realistically probable given the technical safeguards in place. And that assessment is context-dependent. The same dataset can be personal data for one party and non-personal for another. An investigator who archives case images and stores the pseudonymization key locally, GDPR applies in full. A consultant who receives those images without any access to the key, potentially not. Same file, different legal classification, entirely based on access to re-identification tools. Now, a lot of practitioners assume encryption solves this. It doesn't. Encryption isn't anonymization, it's pseudonymization at best. The whole point of encryption is reversibility. You need to get the original information back. So an encrypted case file with a facial image inside, still regulated, still biometric data, still personal data under GDPR. The part that caught most legal analysts off guard was the transparency obligation. The court said the original controller must inform data subjects about all foreseeable recipients of their data at the time of collection, even if those recipients can't identify the person. You can't dodge that duty by pseudonymizing before you share. And the EU's AI Act now layers additional compliance requirements on top of GDPR for any system using biometric data for identification or categorization. Facial images without names still fall squarely into that high-risk category. Most people assume pseudonymization reduces their obligations. The court said the opposite. It creates new ones, documentation obligations. You must record why re-identification isn't reasonably likely for each recipient, and you must revisit that assessment as technology and datasets evolve. It's not a one-time checkbox. So, plain and simple. Blurring a name on a facial image doesn't make it anonymous. If you're the one who did the blurring, GDPR treats you as if the name's still there. And you owe the person in that image a full accounting of everywhere their data might go. The forward-looking reality is this. Every pseudonymized biometric file sitting in your archive is a compliance obligation waiting for a regulator to ask about it. Document your controls now. Full breakdowns in the show notes. Now you know something most people in this industry don't. Use it. And when you're ready to put it to work, caracomp.com. We'll see you tomorrow.